Good morning, Your Honors. My name is Tom Saunders, and along with Heather Crispin, we represent Ms. Shirley Goodman. We're here before the court on an appeal of a final judgment which was the result of a bifurcated proceeding involving inverse condemnation. Below, we only tried the issue of whether or not the plaintiffs had met the burden of proving that there had indeed been a taking. We recognize, standing on appeal, that the factual findings by the trial court come possessed of great weight and deference. In large part, we agree with the vast majority of the trial court's findings of fact. We believe that the findings of fact focus on the wrong aspect of this, number one, but we do take exception to one finding of fact that we believe the record does not support. If I may give you what I believe the facts as found demonstrate. Ms. Goodman purchased the home in 1970. Photographs were introduced at trial showing that at the time of the purchase, the lands around her, specifically Hillcrest and Illinois Avenue, which were directly behind Mrs. Goodman, and the intersection of those two streets was slightly to the northwest of her property. As of 1983, every expert that testified confirmed that the roads had been raised between 1970 and 1983. Each expert agreed that the raising of those two roads impeded the natural flow of water, which generally ran through a drainage basin from a north to south direction across the intersection of Hillcrest and Illinois. The trial court made a factual finding that we believe is incorrect as to the period of time between 1970 and 1983. The trial court found that there was no evidence to show what entity or which individual had raised those roads during that time, but the trial court, we believe, correctly found that as of 83, the road had been raised sufficiently to create the dam. On that point, we put in the evidence of Mrs. Goodman, who testified that when she bought the property, they were all flat, adjacent, and even with her land. We put in photographs. We put in the testimony of Mr. Jeffrey Sullivan, who was a road maintenance crew chief for this area, who testified that in 78 and 79, his machines were out in this area grading these roads. And we put on Mrs. Goodman's testimony that in the early 80s, she saw Polk County dropping dirt on these roads. These roads are clay roads needing dirt occasionally.
Can I ask you a question?
Yes, sure.
You're starting out with disputing the facts.
That one fact only.
So my question was, there's some legal issues that would trump the factual dispute here. One of which was the conclusions of law that there has not been a permanent invasion of the land amounting to an appropriation. How do you get around that? You have intermittent flooding. So before we worry about who caused it, let's talk about, do you even have a legal claim for inverse condemnation? And then you can address the statute of limitations issue.
Yes, sir. Obviously, we do believe that we have a inverse condemnation action, because if you accept the fact, as both experts did, that the damming changed the flow of water, that flow of water also agreed to by the...
It didn't change the flow of water. It caused a backup into the Goodman backyard.
Well, saying two things differently.
The natural contour is going to be the same direction.
Yes, sir, but at this intersection, it no longer was able to flow across Illinois Avenue.
It sort of funneled the flow.
Well, no, sir, it interrupted the flow, and this is a very nuanced point in this record. The trial court found that the historic flow of this water before the raising, agreed to by all experts, was across Illinois Avenue. That it flowed to a point near Mrs. Goodman's property at this intersection. When it was raised, that natural flow across Illinois was stopped. It was dammed. The funneling, I would suggest, Judge, always took place to this corner, flowed across, and got dammed as of 83. When that happened, Your Honor, here comes our taking. Everybody testified that when you have an excessively high rain event, and they define that as 3 to 3.5, 4 inches of rain in a short hour-long period of time, that water which either A, naturally flowed over Illinois, was now stopped, that stopping normally wasn't a problem. because water had sufficient time to percolate. But in these rare 3 to 4 or 5 inch rains in an hour, the water couldn't percolate because of the damming, and now it backed up onto a low area of Hillcrest, which flooded the property, hence our taking.
So let me ask you a question.
Yes, sir.
My backyard's getting flooded intermittently. I wasn't going there.
Yes, sir.
Judge Oldenburg was assuming something else. Hypothetically, my backyard's getting flooded. I believe the county's caused a problem. I call up the county. They make some adjustments in a swale and a berm and things like that. And there's a natural bowl in the road where the water hops over anyway. But once a year, it doesn't take care of the problem. And the county finally says, I can't do anymore. Was there any expert testimony where the plaintiff brought in an expert to say this is what they could have done, these are our damages, that if they fix this, it'll take care of the problem? You know, some other drainage pipe. Was there somebody who testified
Yes,
as
sir.
to some other damages short of saying it's inverse condemnation?
I'm going to have to answer that in 2 parts. There was someone who testified, Mr. Jeffrey Sullivan. Through him, we introduced the county drainage repair report that placed this intersection on the county's list of things to be repaired. The repair was to get water underneath the dammed area, and the result was they didn't have enough money.
So, the county refused to do that, but why couldn't the people claim? And what I'm trying to say is that would be their way to fix this thing, correct?
Somebody would have to get that water under Illinois.
If there's a reasonable method of repair available, the county refuses to do it. Only the county can make those type of repairs. There's nothing they could have done, such as moving their shed or elevating their shed so the water could go on. I think somebody said, oh, they got a shed in the yard and it helps with the water.
The county suggested that on our property that we could do grading and reroute water around our property, around the structure of our property. It's our position that's tantamount to a drainage easement that they're asking us to perform. And I don't find any requirement that we do that. If the county wishes to make the remedy on our property and obtain a drainage easement to go around our property for the water that they're now backing up in these heavy rain events, I think they would have to pay for that. I do not think that they can sit here and say, we dammed up this property. In high rain events, it backs up to a spot it wouldn't otherwise have been, and it flows onto your property in the term the court used, minimally. On that point, I'd like to speak to that. Certainly, Your Honor, to your backyard getting wet, many cases discuss that as minimal invasion.
Well, there's 5 isolated events over a period of 4 years, correct? There's 5 isolated events with this damming.
Over a period measured from the date of their purchase, 40 years. The date of the final damming was 1983, would be more like 23 to 24 years. But the...
Topographically, if you have 4 inches of rain in 1969, it's going to flow, this hill looks like it's got an 18, 20-foot drop down to your property. So it's going to always have flowed across the property. It's just flowing in a slightly different configuration because of the road.
No, Your Honor, and with respect, that's, I think, the nuance that the court missed. This water, before there was any change to these 2 roads, this water always funneled towards the intersection of Hillcrest and Illinois. Before the raising, that water in any type of rain event would be able to go over Illinois and away from my client's property. Once raised in 83, the dam occurs, and when water cannot percolate fast enough, it comes back onto my client's property. I grant you, Your Honor, that we could make drainage easements around us. We believe that's the county's responsibility, not ours. If I may speak briefly to them.
Because your theory here isn't trespass or special damage to public nuisance. It's actually that this flooding has constituted a total taking, apparently.
Correct.
I mean, it might be easier to prove a trespass here than a total taking.
Trespass is clearly an option, and I'll come back to trespass for the statute of limitations that the court wants me to address.
Well, rains again, you've got a new statute. Yeah, probably.
If in point of fact, the event that is causing our problem are these high rain events, and if in fact those high rain events are predictably to occur in the future, case law we've cited in our briefing makes our view that that satisfies the permanency of the problem. And this is not a little bit of water coming into someone's backyard. As these matters progress, this water has now entered the home. It would be our position whether it's minimal water entering your home, an inch, or whether it's a foot of water entering your home. That's coming into someone's home, not their backyard where it's going to percolate in 15 months, as one of these cases found no taking to be. The Hansen case, 15 months it percolated, no taking, and they preferred a nuisance or a trespass action there. This is water that's going to predictably come in our home every time one of these storms comes. The fact that the engineers all called it a 25-year event, they all described that that doesn't mean it only happens every 25 years. As was shown in this record, you can go for a period of time without it at all, and then 3, 4, or 5 can happen. When rain being predictable at that amount can invade my home as a result of lands being raised that altered the flow so that it now dammed up, we do contend that's a permanent taking. The statute of limitations, a very interesting point, obviously. The 1999 event that the court used to trigger the statute of limitations was in this record 2 things. One, obviously, was after 1983.
Now, the trial court didn't actually rule on a statute of limitations argument, did it? Did the trial court give you a ruling you're barred by statute of limitations?
The trial court found that the statute of limitations barred our claims.
Sort of a belt and suspenders order.
It was a belt and suspenders order.
But it didn't need to reach that issue is what I really meant.
It didn't need it, no.
It reached it in an alternative.
Yes, sir. I agree with that. But on that alternative, he found 99's event to be the trigger event. 99 only got a little bit of our, well, up to our patio area, not in our home. The record was abundantly clear by testimony and backup county documents that the cause of that particular flood was the fact that the county had come out and graded Hillcrest Road with an improper slant, that it had always been graded to the north, that somebody came out this time and graded it improperly to the south.
Is Hillcrest the road north, uphill from your house?
Yes, sir, it is.
Okay.
It's uphill from my house, immediately behind my backyard,
Yeah.
with Illinois.
We have the topo map on the bench, by the way, and I have looked at it, I just forget the name.
I
of the
appreciate
street.
that because my easel with this map is at my office. I apologize for
Well,
that.
the county made modifications after the water encroached into the porch in 1999. Theoretically, that would have cured the problem.
Theoretically.
So
and-
I'm not following why the statute of limitations issue is correct in this case.
I don't believe it is. I think 99 is wrong because it's a different cause documented on this record. And they told us they fixed it.
Yeah, precisely, what was it the county did or didn't do between 1999 and 2007? What was it?
All they did really was in '03 they paved the roads finally. And in point of fact, our original
They did
investment,
some trenching or something?
they did put, as we got problems in '07 and '08, they'd dig a trench every so often, but it wasn't stopping the
Do
problem.
you have anyone who said that those things made this, and not only didn't it fix the problem, it made the problem worse?
No, we do not have that. And in fact, I think it did help. It just didn't cure.
Okay.
They made game efforts since their fiscal hands were tied. They made game efforts, including coming out to us and telling us what we could do. Our position on as we.
Is there testimony that
Yes, sir.
the county thought this had fixed the problem?
They thought they fixed it in '09. There was a memo to that effect. And so I think the statute of limitations begins to run in '07. And I think we're timely. But I do want to be clear with the court. I do dispute there's no evidence as to who did this between '70 and '83. But every other fact that the judge puts in here, I largely agree with. It just misses the nuance of that water wouldn't be at the low point.
Does it make any difference who did it between 70 and 83? I mean, this is a...
You know, Judge...
I'm assuming this is a platted county road, isn't it?
It is, sir, and there is, of course, the statute that says if you've maintained it for 5 years as a county, you own the road. But to be honest with you, I believe it would matter. The suggestion was made at trial that we don't know who did it. Mr. Campbell and I had a stipulation in the beginning of trial that massaged itself during trial. Through no fault of Mr. Campbell, he's a fine attorney, a wonderful fellow to try the case with. We then put on evidence to plug that hole. And we said, Mr. Sullivan, weren't you grading out there in '78 and '79 before the 1983. Mrs. Goodman, did you see them bringing dirt out there? Yes. So to the extent that I have to show it, I think we did, and nobody suggested anybody else did it. So I think we do know who did it there, and if 83 forward is what this judge is looking at, I'm not contending it got worse after 83. I'm contending the bad thing happened from 70 to 83, and that the problem we suffered first showed in 07 when we had the very first of what was going to be almost year after year for a while of these 25-year storm events. Minimal water inside my house, I think, is a different thing.
That only happened one time.
Twice. So 07, 08?
The tile porch you're counting is inside the house?
No, Your Honor, I believe tile porch was twice. I believe water got in the house twice, although one may have been after 08 when she left. She did go back every so often in big rain events and check. The fact is, however, it's continuing and is predictable.
Okay.
Thank you.
Thank you. Mr. Campbell?
Good morning, Your Honor. It's a pleasure to be here. Hank Campbell, representing Polk County. I think it interesting as I listen to the argument and read the very well argued brief as to trying to find any case law whatsoever. If you agree with the findings of fact, which appellant has conceded are supported in the evidence, if you agree with the findings of fact other than who may have done this raising of the road, because I do think the evidence is very ambiguous as to who raised Illinois. You'll hear a lot of testimony about the raising of Hillcrest. The problem was raising the corner of Illinois. We don't know when it was done. We don't know who did it. I don't think it's an important fact, but it is not clear in the record. But if you read the findings of fact that Judge Self entered, try then to find a case that would support inverse condemnation as opposed to trespass for that factual scenario. I would tell you the cases we have cited, the bulk of which begin with the letter B, there's a Diamond K one, the bulk of which are reversing findings of taking, are much more substantial as far as flooding to support inverse condemnation. And the probability of the reoccurrence is much more established in those cases in which findings of taking were reversed.
If it rains 6 inches in June and the water does this all over again, does he have a new cause of action for trespass?
Certainly, Your Honor. Yes, if he can prove, again, that some changes occurred. Now, we don't concede that. Again, who did the change on Illinois did not redirect all this water to Mrs. Goodman's property. That has been the natural place for the flow off this very large hill right next to Crooked Lake, heading down to Crooked Lake. That has been the natural funnel to the backyard since way before then. Every bit of testimony, including Mrs. Goodman, that's where it always crossed the road. And in fact, a number of the county's actions...
The fog of the hill, the topographic map shows us the hill, but doesn't kind of show us.
It keeps going down to Crooked Lake, actually.
Right.
It goes to 17. There's DOT drainage between Old 17 that goes to Frostproof and Crooked Lake, but it's all heading downhill substantially to Crooked Lake. But once again, and many of the actions of the county, including the action that was originally complained of, the complaint in this case and the plaintiff's expert in this case originally attributed the increased rain runoff to the paving of the roads. That was his opinion. There's an affidavit in the file to it. That's the allegation of the complaint. Didn't have anything to do with Illinois. We hired an expert transportation engineer who came out and determined that there has been some small, minimal amount of increased runoff that is now being dammed because it used to flow past the Goodmans to Crooked Lake. It now comes back around and goes over that natural flow at Goodman's. But the testimony is unequivocal. From plaintiff's expert, I can't measure it. I don't know how much more it is. From our expert, it is minimal, small, if any. So what we have here, as opposed to the cases in which a county or DOT or SWIFTMUD has intentionally changed drainage to remove it from one property to another, which is the basis for many of the cases that actually find taking and flooding. And as opposed to an event that you can anticipate is going to regularly happen, and the language obviously is that it's a permanent condition. We have a case here that over 40 years, twice some water has entered the air-conditioned home of Ms. Goodman. And it hasn't happened since the last repair. It did come on the porch was the testimony after she moved out, but it hasn't happened since the last repair of sandbagging by the county.
Well, let me ask you a question.
Yes, sir.
You had Hurricane Charlie, Francis, and Jean, and none of this flooding occurred.
Yes,
so the evidence was that it occurred during unusually high torrential downpours. The average rain didn't do it.
And even abnormal rain.
You can't predict how often these torrential downpours would occur.
Actually, the only testimony at trial is our expert that these two events were 25-year events.
And we can't predict if these torrential downpours would occur with sufficient severity and regularity, not only to constitute a taking, but to occur whether there was road improvements or no road improvements.
Yes, Your Honor.
And the only follow up a little bit though on that. Even if they only occur every 15 years, if the evidence were that the county created the situation that causes every 15 years, it might make that property really hard to sell to anybody. So, I mean, does the fact that it's infrequent say that it can't be inverse condemnation?
I think so, because that's exactly what the legal standard is for inverse condemnation.
Okay.
And I'll cite Hansen as the most recent of the cases in our string side of cases, but I'll note that we previously held that a county takes private property when it directs, again, county intentionally directing, something not here, a concentrated flow of water, that clearly we don't have here, a concentrated flow of water, from one property into another, permanently depriving the owner of all beneficial enjoyment of their property. The suggestion that every 25 years or every 15 years you may get some water in because you're in the bottom of a natural bowl. By the way, there are two acts of God here. There's flash floods that only occur every 25 years, and this property is actually, and there's a survey in the file, is in the bottom of the bowl, and the Goodman's back door was the bottom of that bowl, straight from the funnel where it comes across Hillcrest Drive. To assert, back to Hansen, an inverse condemnation claim based on such governmental action, the property owner must demonstrate that the government's action constitutes a substantial interference with their private property rights for more than a momentary period, and it will be continuous or reasonably expected to continuously recur, resulting in substantial deprivation of all beneficial use of the property.
Was there testimony that the property couldn't be sold as a result of the flooding?
No, Your Honor. And in fact, the county made repairs. They paid, and this is in the record, they actually paid for drying it out. They were negotiating additional repairs in 2008 when the Goodmans moved out of the property to another property in their family in Bartow, and at that point basically abandoned the property. The negotiations with the county over damages for that flood broke down because of some of the claims that were being made, which is obvious in the transcript of this particular record. But the county was responding to a damage claim. And that's what this truly is. I mean, if there's a claim here that the county has caused something, it is a simple trespass. It is not a continuous, permanent loss of use of all beneficial property, and thus is just not an inverse condemnation claim.
So what are the damages for a simple trespass?
I'm sorry?
What would the damages be for a simple trespass?
Well, one might be correcting it. We put in the evidence. Our engineer's correction of this from the Goodman
standpoint. They didn't have an
standpoint.
alternative count for simple trespass, though.
I'm sorry?
They only sued for inverse condemnation.
That is correct. Yes, sir. There
So we
was.
can't send it back for further findings of fact or with leave to amend. It'd have to be a whole new case.
No, sir. They elected to pursue inverse condemnation. But we did put in the testimony of our engineer. The engineer's fix was less than $5,000 and your property is fixed. But the county, the suggestion is we built a retention pond or we're telling them to fix it. We can't go on their property and fix a drainage question. But the fix of this minimal problem was $5,000, and Mr. Sullivan actually testified. He's our head of maintenance that testified. He actually testified as to how you could do this and how he talked to Mr. Goodman about how he could fix this problem by just minimally raising the level there in the center of the property as it goes to the back door, and then it would...
Regrading.
Yes, sir. Then it would flow naturally. And there are lots of other...
Without changing anything on Illinois.
That's correct. That's correct, Your Honor. There have been improvements, and if I'm running out of time, I
you're doing fine.
There have been other improvements made by the county which have helped. We don't know the extent of that since 2010 is the last testimony I think we have.
Well, tell me about, are you arguing the statute of limitations, the judge was correct on that?
I do think the statute of limitations is correct. I think it's a catch-22. I don't think there's been an inverse taking. I don't think it comes close to a single case in the state of Florida for intentional flooding or even unintentional flooding.
The county makes repairs in whatever it was, 1999, and there's no flooding till 2007. How could you argue the statute of limitations began prior to 1999?
I would say the catch-22 is counsel for plaintiff just argued that 07 was the trigger. There's no difference between 07 and 1999.
I'm just saying, if I'm a homeowner, the county says, we fixed your problem, you're fine, you're good to go, and next thing you know, I'm good for 8 years in 2007, now I've got the same problem. Why wouldn't that be the statute of limitations beginning point? Why is that unreasonable?
Because it's the same cause. I think the Suarez case from the 2nd DCA and the other Sarasota Memorial, that's not it, Sarasota something versus Sarasota, would show that that's not estoppel. The county coming out and trying to fix from a maintenance standpoint cannot constitute estoppel for statute of limitations. And Mr. Sullivan's testimony was the dozens of times he spoke to the Goodmans, what he said was, we've done everything from a maintenance standpoint we can do. This is a drainage issue. We cannot stop the water from flowing downhill. So it became a drainage issue. Mr. Sullivan's testimony was somewhat different than Ms. Goodman's about the conclusion that this was fixed in 1999.
In the Hanson Deland that you were talking about, there's emphasis that the flooding in that instance involved a low level of the property, but did not involve the home. And so, at least from a statute of limitations standpoint, the first time the home was affected by this flooding was after 1999, apparently.
It actually came into the porch in 99. The first time it came into the air conditioning portion of the home was in 2007. Yes, sir.
Yeah. Okay.
I would just, in conclusion, and I'd be glad to answer any more questions, but in conclusion, I would cite to the trial court's conclusion because, honestly, it could be a relief of plaintiffs. Maybe we could improve the advertising for claimants' lawyers and plaintiffs' lawyers if in fact, the Goodman's position in this case were true, because the horrible of horribles, and it's outlined in that conclusion, and I obviously argued that to the court at the time, is if this were enough to trigger inverse condemnation, then any time that a flash flood occurred and somebody sustained damage of this type to their home, then you could find a drainage district or a county or a DOT who has made improvements to roads and just simply show that somehow that increased without quantifying the amount of increase, without there being any intent to increase, without there being any benefit to any other property, and it would give rise to an inverse condemnation case without statute of limitations. And that simply is not what inverse condemnation is meant for. Thank you.
Thank you. Mr. Saunders?
Thank you, Your Honors. Very briefly, only a couple points. The hurricane question I thought was an excellent question. It puzzled us a great deal. In 2004, we had Andrew, Francis, and Gene, and they dumped just a ton of water, especially in this area of Polk County. Those experts addressed that at trial, and I suggest it makes sense. Those storms came at a time when the water was already, the ground rather, was already percolated, an awful lot of wetness, so water can absorb quickly. They further said that the true distinction here is that that water was slow in falling, and the ground had time to percolate it, so the dam created at Illinois and Hillcrest never got so big as to back it up to the low spot on Hillcrest. Specifically, they used the Hurricane Gene, that, if you remember, was almost statewide, terribly slow, not much wind, but a steady amount of rain. It was able to absorb it. I am not, nor is Ms. Goodman, advocating that any time there is a flash flood that damages somebody's property, there should be a cause of action for inverse condemnation. I take great issue with the trial court's suggestion and Mr. Campbell's suggestion that Ms. Goodman's home is at the bottom of some hill. It is lower than the top of the property to the north of her. But without question, the historic flow of this downhill was not onto her property. It was across Illinois. I would rephrase Mr. Campbell's last question. Anytime a county does something to stop that natural flow of water, if that action causes even minimal water in my home, and that rain is likely to occur in the future, I suggest I have an inverse condemnation. As to rain, they call it a 25-year event. Hurricane Andrew was a once-in-a-100-year event. The 3 hurricanes we had in '04, none of those were supposed to happen. A 25-year event here flooded us in 2007, 2008. It came again to our porch in 2009. It's true we had no trouble from '83 to 2007. That's 25 years, or 23. But then we had 4 events right in a row. And this court's opinions have said, the Hansen opinion recognizes this court's opinion to saying rain, if that's the cause, is of sufficient permanency. This is not just every time it flash floods. We're going to have these rains again. We had 4 in the last 6 years. And I don't think somebody should be forced every so often, whether it's every 15 years or in '07, '08, '09, '10, to constantly sue for trespass when the rain is going to keep coming.
You got a case, by the way, that says anything about inverse condemnation being available under those circumstances rather than a trespass? Is there a case that you want to cite that says exactly what you said, that it constitutes inverse condemnation and not just a trespass?
I have, if I follow your question,
Yeah.
Your Honor, I have cases that say, of course, governmental action changing natural contour of water that causes damage.
Okay.
I also
At
have
those same cases, but I'm talking about a more factually on point with this situation.
No, I do not. No, I do not. I keep running into the word minimally.
Right.
And I'm drawing a distinction and asking you to.
It's minimal to the judge, it's a maximum to the client.
Well, it's also the home, and I can't suggest that. I suggest that should be given a little special weight. Flooding my home is different than flooding my front yard every so often, and South Tampa gets wet all the time. Yeah. Flooding my home is different, I suggest.
I got you.
Thank you.
Thank you. Court's going to take about a 10-minute break. When we come back, we'll pick up the last case, which is Gallon versus Geico.
You're like, oh good, great for me, bad for her. No.
I've had 2 other. I'm appealing, yes. On the wrong side of the judge.
You know what, I would believe it.
Yes.
Right, I get to write down all the places where they